So, welcome to this talk, which is glamorously called Earn More Whilst Charging Less. My name is Tom Blackburn. I'm what I like to call a costs expert. I'm not sure it's definitely not formal. Let me tell you a little bit about me. So I've been head of costs at Irwin Mitchell. I've worked at Pinoni up in Manchester before, and I've spent about 15 years as a costs litigator. My clients tend to range from firms of solicitors, everyone from Mishcons to Collier Bristow, large firms to high street firms, depending upon the cases that they've got on. And my practice area is probably 50% what I would call traditional costs work, so bills of costs, points of dispute, points of reply and hearings, as well as budgeting, of course. And it's 50% what I term the weird and wonderful. And that's things like retainers, both drafting, checking, challenging them. It's sorting out funding agreements. It's drafting weird and wonderful retainers. It's things like group litigation orders, anything out of the norm. The aim of today, and I promise this won't take an hour, and it will be semi-interesting because I'm going to get you to do all of the work. The aim of today is firstly, to put more money in your pocket and increase your billings as a litigator, which I think we'd all like. And secondly, is to increase client satisfaction. And the two aren't at opposite ends of the spectrum. There's a way of achieving both in the right cases. And a lot of what I'm going to talk about today is predicated on the basis that you pick and choose these types of retainers and these types of discussions with clients for the right cases. So I'm going to get you to do a lot of the work, and it can be, we've got Matthew here who may ask some questions as we go along, and I'll make sure that I repeat those loudly so that they're on the recording. It may be that you're working through this at your home office. If anyone's jogging whilst listening to costs, please turn over and listen to some music. You'll jog faster. But if you're working through this on your own, just write down what you believe the answers to be. So, question one. Question one is, your client has asked to pay you, or wants to pay you, £150 per hour throughout the case, and wants you to recover all other fees from the other side if you win. That should read if you win. The case is a claim for £30,000 of computer equipment that our client leased to company A after receiving a credit report from company B stating that they were at low risk and very creditworthy. The claimant is based in Reading. So this is the first of 4 examples, and in each example I'm going to ask you 3 questions. The first question is what the client proposing to you legal? Can you do it? The second question is, what hourly rate do you think the client would agree to pay? Hopefully in this example it's on the first line, you can spot that. And then the third question is, what hourly rate do you think would be recoverable inter partes? So let's go through those in stages. Is it legal? Well, the client wants to pay you something as you go along. That's perfectly fine, and wants you to recover all other fees from the other side in the event that you win. Also legal. That's fine. The case it relates to is litigation. That's fine. The claimant's based in Reading. What we've just described there is what we call a discounted CFA. The discounted element of it is the fact that we're going to be paid £150 an hour throughout, regardless of win, lose or draw. The CFA element is a conditional fee agreement element, is that you recover all other fees from the other side should we win. So it's predicated on winning. Technically what we've just described is a discounted CFA light. The light element is that we cap our charges to our client at what's recovered inter partes. Yes, it's legal. It's something that people like Stewart's, Leaday, Mishcons, big heavyweight litigation firms act on every day. I draft them all of the time. One thing I would say is that you have to be confident that you're going to win, firstly, and secondly, you have to be happy with the hourly rate that you're getting paid, even should you lose. And £150 an hour might be too low for some gunnercooke litigators. That's absolutely fine. So is it legal? Yes. What hourly rate do you think the client would agree to pay? Well, they want to pay £150. Here's the interesting point. What hourly rate do we think we get into parties? Matthew, have you got any thoughts on this? Okay, so you think we could get guideline hourly rates? Yeah, okay. I use this case as an example because it's a real case. It was one of mine, and we went to a 4-day detailed assessment hearing on it, and hourly rates were set into parties. The case was actually a case called Prodec, and in the quite remarkable situation that this occurred, we ended up spending £350,000 worth of costs. The other side on a £30,000 claim. The other side, who were the credit referencing agency instructed Bird & Bird, who also spent over £300,000 worth of costs. In effect, it was actually a challenge to the credit referencing agency's terms and conditions that governed hundreds of millions of pounds worth of work for them. So the trial judge described it as a test case, as did the judge on detailed assessment. These are the hourly rates. So there's the citation, Prodec versus N2 check, 2011. It seems like it was yesterday for me. We got £425 an hour for the partner inter partes, £350,000 worth of costs, which were proportionate when the claimant went on and won £15,000, and the clients acted on a discounted CFA light, which I've just described, and there's the citation allowing the same. The fact is, in this case, the law firm, who were Pitmans, who I think have just merged with somebody else, only recovered £425 per hour because they thought about the agreement that they get the client to enter into fairly early, because the client only wanted to pay £150 per hour. But you can see, if that was your money and your case, you're recovering a huge additional sum into parties if you strike the right agreement with the client. The second question I'm going to ask you is, your client wants to pay you nothing but give you 25% of the value of the claim up front for you paying them £10,000. The claim value is £2 million. The case is a claim for unpaid invoices against a building contractor. The claimant is based in York. So taking those points in reverse, the reason why I keep mentioning where the claimant is based is because that's one of the first things the court will look at when assessing reasonable hourly rates. This case doesn't warrant any involvement in London. It is perfectly suited to whichever district registry is closest, whether it be Newcastle or anywhere else. The fact that the client wants to pay you nothing but give you 25% of the claim value, have a think about that for a second. But it's also a transaction. You would give them something. You would pay them £10,000. So going back to those the first three questions: is it legal? What hourly rate do we think we can get from the client? And what hourly rate do we think we can get into parties? Well, I think you won't be surprised to hear that it's illegal pursuant to the Damages-Based Agreement Regulations 2013. The client wanted to pay us nothing, presumably for cash flow reasons or they're impecunious. The fact that they're based in York means that we'd probably be looking at around £300 per hour for the lead partner conducting this case. It's only illegal because the client wants us to pay them some money. If the client didn't want us to pay them any money, it would be perfectly legal, and what we've just described is a damages-based agreement. Interestingly, it would also be perfectly legal for you to take out third-party funding from a third-party funder, or litigation funding as it's commonly called, and be paid something by them as you're going along for some or all of your 25% of your share should you win the case. That's called a tri-party agreement. It's fairly common now in litigation funding. Rather than the funder taking a multiple, they'll quite happily pay something for a percentage of the value of the claim. But it's definitely illegal because of the money that we're being asked to pay back to the client. When the client makes such an offer, it's obvious that they're happy to give something away. Now, subject to the damages claim being robust and subject to your merits of the claim being robust, there is always a way to then monetize your time. And that's one of the things that I specialize in, sitting down with the relevant parties and saying, well, the claimant's willing to give away a quarter of damages right from the outset. You sit down with a legal team, and this can or can't involve counsel, it's completely up to you, and we can work out how we project manage the case to make sure that everybody is happy with being paid something or not being paid anything, and then how we manage those stages to make sure we stay on track. Question 3 is a detailed one. So your client is mum and dad. They can't pay you anything, but their high net worth son can. He wants to pay you a normal hourly rate of £250 per hour for a case against a pharma company who sold mum and dad £500,000 worth of drugs, only for them to be told that the drugs were still under license and needed to be returned due to the financial stress this placed on mum and dad's business, which were a chain of pharmacies. They go under. The chain of pharmacies were all based in Northampton. The value of the business is about £7 million. So, on the face of it, we've got a £7 million claim against a large pharma company who we say put our mum and dad business out of business. They can't pay anything because they're impecunious, but their high net worth son can. So, taking those points in turn again. Number 1, is it legal? Number 2, what's the client's hourly rate? And number 3, what do we think the inter-parties hourly rate is? Well, the answer is it is legal. It's another what we call triparty agreement. It's a discounted CFA, and the son is what we call a pure funder. Now, it's legal because the son is paying fees on their behalf, which is absolutely fine. The son is a pure funder, pursuant to the case that's mentioned and cited properly there, in that he has a vested interest in the outcome of the case, but only from a monetary point of view for his parents. And we'll come back to that in a second, because it's important that if the mum and dad go on and lose, the son may then be liable for the other side's costs, pursuant to what we call the Arkin cap. The £510 per hour for the partner is because it's a London case, it's chunky, and I would say, in my limited experience practicing what I would call proper commercial litigation, that it's going to be complex and hard fought by the pharma company on the other side, who will have much deeper pockets. Now, this is another good example of where someone can monetize their time as they're going along at £250 per hour, which I think most of us would be happy with. But the case warrants, so long as we win, a much higher hourly rate. And that's one of the things that I'd like to get across to everybody listening to this, and to Matthew and anyone else who I speak to within gunnercooke, is that there's normally a dichotomy between what the client either has the ability to pay or wants to pay, and should you go on and win, what actually is reasonable from an inter-parties perspective. Now, it's against this backdrop that we always need to remind ourselves, does the defendant, or if we're acting for the defendant, does the claimant have the ability to pay fees if we obtain a cost order against them? If the answer to that is no, then these types of win and wonderful agreements that I'm now talking you through probably shouldn't be considered, because all you're doing is adding further bad debt onto somebody who can't pay, and effectively wasting your own time. But when they do have the ability to pay, when they are good for the money, then we can double our fees on this present case, by way of example, purely from the fact that the client can't pay as much as they probably should do, and the court would give as much more into parties, because the pharma company is going to instruct Bird & Bird, Mayor Brown, any other big London law firm who's going to represent them at these types of hourly rates. This is what the court would award us into parties. So once we've scoped out what the instruction is, what our advice is, and then we're working out how to retain the client, it's at that point that we need to sit down and think. And I think litigators, we're all quite bad at this. We want to get our teeth into the main dispute and the legal intricacies and of causation, etc., in the present case especially. But we need to sit down and think, how do we effectively plot this as a mini business, this case? How can we recover more fees from the other side if we're successful? And all of these cases are based on the fact that we are going to be successful. We will achieve some sort of win. And a win can be a payment of £1, a win could be a costs order, a win could be an apology. We can define win in a very either broad or narrow way. But it's definitely after the initial advice has gone off to the client and they've said that they want to proceed, that we need to sit down and work out how we're going to get the most out of this case for us, whilst also keeping the client happy. Going back to that first thing of what we want to achieve, well, if we said to the client we simply charge them £250 an hour throughout, they're going to say, fine, that's what we can pay, and they'll pay you as they're going along. If you turn around to the client after the initial advice has been given in this case and say, this case is quite difficult, it involves some complexity, we're going to be up against a big law firm, my hourly rate for this type of case normally is anywhere between £400 and £600 per hour. That's what the other side will be paying their lawyers, and so we need some form of equal footing. I'll discount my rate down to £250 so that your son can pay it, and regardless of win, lose or draw, that's what you'll pay. But if I win, I'll charge that £5, £10 to the other side, and hopefully I'll get predominantly most of it back from them. Suddenly the client feels that you've got skin in the game, you're invested in the case as much as they are, because you're racking up hundreds of hours at a half discount. That's what we mean about increasing client satisfaction. They feel that you're part of their team, that you're on their side, and that you're feeling the pinch at the same time as they are. This, offering such an agreement in this case, rather than simply saying, yes, pay me £250 an hour throughout, will definitely increase client satisfaction. So, question number 4, and this is the final one, you'll be pleased to know. Your client is a dairy company called June. It's been fighting a vicious and hotly contested dairy war. That sounds, it sounds fictitious, but this is based on a real case, and it did really happen. They did go embroil themselves in a dairy war against their biggest rival and local competitor, who we're calling Steve. Steve, it is alleged, stole data from June and is operating illegally. June has paid you £300,000 to get to the PTR stage, but has now run out of all cash. They're borrowing from the bank just to pay their workers' wages. June has said, can you repay them the £300,000 in fees that they've paid and act on a complete no-win, no-fee that is retrospective back to the date that they first instructed you? Steve and June are based in Solihull. So this is based on a real case, and the law firm in question actually did what's being asked, and we'll go through the legality of it in a second. But the dairy war carried on. So this was a hotly contested case. It took 2.5 years to get to PTR. It went to a 2-week trial. June won, Steve appealed. June won that, Steve appealed, June won that. So we had 3 rounds of litigation, 2 appeals. We ended up with 3 bills of costs. Number 1, is it legal what June is asking you to do? Number 2, what hourly rate do we think we can get from the client based on the fact that it's a very difficult case, definitely is not going to settle, and we know that the other side are fighting everything tooth and nail, lots of interlocutories, etc. And also the fact that this case is in Solihull, and what inter-parties hourly rate do we think we can get? Well, the answer is it's legal. The case was JN Dairies versus Joe Hell Dairies. I had a really busy 2011. I completely forgot that JN Dairies and Prodec went to the SCCO at the same time. It's completely legal because you are entitled to enter into retrospective agreements with your clients. Those in the personal injury and clinical negligence sector do this day in, day out. They investigate for a period of a couple of months, and then they sign a retrospective retainer with their client back to the date of first instruction. There's lots of good case law on the point. Making something retrospective back to the date of first instruction or a specific date, perfectly legal, no one's going to prison. You backdate a document, someone's going to get struck off, there'll be a claim on our professional indemnity insurance, and there will be tears before bedtime. So there's a very distinct difference between making something retrospective in effect and backdating it. When we come to hourly rates, the client in this case, JN Dairies versus Joe Hell Dairies, they were again put under lots of financial pressure. I acted for the claimant, lots of financial pressure by the defendant. They couldn't afford to pay what I would call decent hourly rates. From memory, I think they were paying 150 or 200 pounds an hour as they went along, and then they ran out. It was TLT, a law firm in Bristol, who agreed to do this, and they only agreed to do it because they were always convinced that their client would win. And the fact is that they were just before trial. They knew that there would be an inter-parties cost award in the next 6 months, and they as a law firm could afford to do this. We as virtually independent practitioners, I think we think twice about paying someone £300,000 back. But let's work that through. If we get halfway through a case and the client says, I'm very sorry, for whatever reason, funds are short at the moment, can we change our retainer and make it retrospective in effect? Absolutely. If we wanted to change our retainer down from, let's say, £200 an hour to £125 per hour, we could do that. We can make it retrospective if we wanted to, and we could keep all of the cash that we bill today and then bill it at £125 per hour. That wouldn't involve a fee going back to the client. I would suggest that we also get something in return, that we charge a higher success fee to the client in the event that we won. We charge higher hourly rates to the other side, potentially. But making something retrospective all the way to, and we could have done this up to probably the morning of trial. I think once trial started, it will be a different proposition. Now, the client was based in Solihull. This actually happened in the Midlands. We got £410 per hour for the partner and £315 for the grade B. Bear in mind, this was back in 2011 when I'd sorted out the costs. So this was at least 10 years ago that the first case was going ahead. So those hourly rates, I would say, are very healthy. Me as a gunnercooke lawyer, I'd be very happy if my client was paying me that as we go along. The whole point of this talk is that most clients either can't or won't agree to pay those types of hourly rates, or even higher as the case is going along. So how do we monetize our cost recovery against the other side? SF from claimant means we can seek the success fee from the client as long as we win. And what I've just described as retrospective CFA, making something retrospective for 2.5, 3.5 years is still fairly novel. Making something retrospective for a couple of months, maybe 6 months, is routine. There are firms that do it up and down the country, day in, day out. They are the 4 questions. There are some consequentials which we need to think about as practitioners. So, do you have to file and serve a notice of funding? Do you have to complete a risk assessment? Do you have to have a signed CFA, DBA or retainer letter? and what do you put in the precedent H budget? So let's take those in turn. Do you have to file and serve a notice of funding? No, you don't. The other side aren't entitled to know that you're acting on a conditional fee agreement, whether it be a discounted CFA, a full CFA, a retrospective CFA, any of the guises that I've talked you through. It's none of their business anymore because we're not seeking a success fee from them. Or a DBA, Matthew's just asked. Absolutely, they're not entitled to that. And if they made a Part 18 request for further information, it would definitely be refused unless they were really contemplating a security for costs application, at which point we may have to disclose how the case is being funded, depending upon the financial circumstance of our client, but that's a completely separate issue. If they just ask us out of the blue because they're being nosy, they are not entitled to it. We do not have to tell them post 2013 anymore. Do we have to complete a risk assessment? Absolutely, and I'll talk to you about this on the next slide because lots of people and lots of practitioners are, I think, falling foul of this. Let's talk about that more in a second. Do we have to have a signed CFA, DBA or retainer letter? I'm going to give Matthew away here. He's nodding. Do you think yes? No, we don't. No. CFAs don't have to be signed anymore. DBAs don't have to be signed. Retainer letters don't have to be signed. The fact is, if we send the client an agreement, we give them the advice and they carry on instructing us, that is our retainer, is completely fine. From a practice perspective, and I can probably see or hear our compliance team jumping up and down, I always make sure that my clients sign those because I think it's just better to be safe than sorry. But if they're not signed, it doesn't invalidate them, they don't fall foul of the regulations, and you do still have a valid and proper retainer. And then the last question, what do you put in the precedent H budget? Have a quick think about that. I'm going to go on to the next slide and talk about risk assessments, and then we'll come back to the precedent H budget. So those next steps, the answer is no. When we come to the risk assessment, definitely, absolutely, you must. There is a High Court case, and this is a piece of hotly contested case law at the moment, where people are just simply charging clients in the personal injury and clinical negligence fields 100% success fees for absolute guaranteed winning cases. And it's taken 5 years for people to realise that shouldn't be happening, that the risk assessment is a calculated set of hurdles that you go through when carrying out your retainer with your own client. And because the client is paying the success fee, it can contain things like postponement. The fact is that we're not going to get paid our full fees until we make a recovery from the other side. If we're acting on a discounted CFA, by way of example, it can contain certain things of a solicitor and client nature, because the other side don't see it, they don't know that we're acting on this. The reason why we have to do a comprehensive risk assessment at the time the CFA is being entered into is from a solicitor and client proceeding basis. That if we went on to win and the client for some reason was unhappy with what we charged, either by way of our normal fees or our success fee, if it was always a routine case, a claim for unpaid invoices, we charged 100% success fee to our own client who, at the time, in their distress, they agreed to, and then much later on, once we've charged them, in an example, £50,000 as we're going along, we win, and we send them another invoice for another £50,000. If we don't carry out a risk assessment, the client has an excellent prospect of not only knocking out the additional £50,000 that you want to invoice, but the original £50,000 as well. The fact is, if you don't complete a valid risk assessment at the outset, you are very likely to invalidate the whole CFA. I cannot stress that enough. And on to the last question on budgets. What do you put in the budget? Well, it's all case specific. If we are acting on I'd like to think that truck had just reinforced my point on risk assessments. It was probably something different. This is being recorded in the London office, so someone's obviously crossing the road outside bank when they shouldn't do. What do you put in the present H budget? Well, let's talk through some various different scenarios where we're acting on a discounted CFA. So we've said to the client, pay us £250 an hour all the way throughout, but I'm going to claim £500 an hour from the other side. In the budget, we put £500 an hour all the way through. Where we're acting on a full CFA, either client's paying nothing, but if we win, we're going to charge £500 an hour to the other side. Again, we put £500 an hour in the CFA. Let's talk through two tricky scenarios here. The first is we've already done the budgeting exercise, but because the case has got more complex, or because the monetary strain that the client is now under, we've agreed higher hourly rates in the event of a win and lower hourly rates that they pay us all the way through, and we've made this retrospective. What would happen then in a budgeting scenario? Well, we'd serve and file an updated budget, and our hourly rates would actually go up on an inter-parties perspective, because we're seeking to recover more on an inter-parties basis. And that's a job for a cost specialist. There are good arguments for the budget going up, because if the case has got more difficult and or the client is now in a much more difficult financial position as a result of the other side's actions, the ongoing financial stress adds to the skill, complexity, responsibility of the lead partner, and accordingly we are completely warranted to put our hourly rates up, which is something that we're entitled to do, and it would probably require a 30 to 45 minute cost and case management hearing for the court to rule on that. What do we put in our budget when we're acting on a DBA? And this is something that I see people getting wrong probably on a monthly basis. Fortunately, no gunnercooke lawyers. This is all from an external perspective. Lots of people don't file budgets when they're acting on a DBA, which is wrong and in fact is negligent. First of all, it flags up the issue of their retainer with the other side and gives the other side some cause for concern, and also a very good open doorway to query with the court why a budget's not been filed, which then I think we'd be under an obligation to answer, and it's from that point that they may go down a security of cost route. So we've been negligent by not filing a budget. But secondly, we should recover as much costs from the other side as we possibly can under a DBA, and then we take a percentage of the costs and damages actually recovered. And this is a piece of negligence that I'm acting as an expert witness on a case at the moment, which may or may not go the full distance, where the client has complained that her law firm didn't charge the other side enough, and thus they've been negligent in not recovering enough, and she's bringing a negligence claim against them. So when we're acting under a DBA, we still file a budget, and we are, if anything, we're under an obligation to charge as much as we possibly can to the other side when we're acting under a DBA. I've included at the end of the slides, and there'll be hard copies for those who attend in Manchester tomorrow, a bit of a dictionary which gives you a quick summary on all of these things. So light, backdating, retrospective, DBA, partial or hybrid DBA. Lots of people think that partial or hybrid DBAs are illegal. They're not, they just need to be done properly. CFA, discounted CFA. I put in the name of my cat, Charlie, there, just to see if anyone's still awake at the end of listening to this. Hopefully not whilst you've been running. Scalable DBA CFA, the CFA regulations, DBA regulations, and then the SRA Code of Conduct, which is very, very important. I see people falling foul of it every day, and sometimes I'm instructed by clients to pursue cases against other law firms, fortunately not against gunnercooke, but some very, very well-known law firms who fall foul of things. What I would say, and this is my advice to every client of mine, is once you've taken on a client, once you've done your initial scoping, you've read in, you have provided advice to the client, and you're about to press the go button, you're about to do some serious work and agree a retainer with a client, I have 10-15 minute chats with people every day, and I don't charge for it. It's very much the same way that as commercial litigators you advise your clients. If there is something that can be done that's fairly cheap to put in place, that's hopefully simple to explain to the client that I can assist with, that makes you more money, then this last 45 minutes has been worthwhile. If anyone's got any questions, please feel free to email or call me. It is just normally a quick 5-10 minute chat, absolutely max, because I've seen everything, and there's ways of doing things that hopefully will lead to happier clients for you and more money in your back pocket. But thank you very much for listening.